right. Well, welcome, friends. I'm Lynn Kilborn, and I serve as the Director of Development for the Methodist Foundation for Arkansas. And I'm thrilled to welcome you to this month's Learning Zoom on demystifying wills and trust. This is obviously a topic that folks have some great interest in. All of us really want to um, demystify our understanding of wills and trust. So we are grateful that you have tuned in with us today. I am here in our Little Rock office, and I'm going to ask, we have a few other staff members who are on this call as well. We are spread out, um, working in different places today. So I'm just going to call on our staff who are present to introduce themselves. And I'll start with Amy, and then I'll turn it to CE, and then to Amy Forbes. So Amy McGovern, CE, and then Amy Forbes, if y'all will introduce yourselves.
Good morning, everyone. My name is Amy McGovern, and I am the Northwest Arkansas Development Officer. We opened an office up in Rogers about 4 years ago, coming up on our 4-year birthday. So happy to be with you, be here with y'all today. Easy for me to say, and looking forward to hearing from Jarred. Thank you.
Yes, and CE.
Good morning. I'm C. McAdoo. I'm a gift officer and work in the Little Rock office and relate to churches in Central Arkansas as well as Pan Methodist churches. Thank you.
Thank you, and Amy Forbes.
Hi, I'm Amy Forbes. I'm the communication manager here at the foundation. I've been here less than a year. I started in December and have worked at the Arkansas Conference and at Hendrix College. I'm glad to be here now. I am actually preparing the final proof of our Legacies quarterly newsletter today. So y'all should be receiving that in your mailboxes soon.
Excellent. Thank you, Amy, and CE. Thank you all for joining us. I'm thrilled to now introduce our guest speaker. I'm very proud to introduce y'all to Jarred Kibbey. Jarred is, well, first of all, he's a member of our Professional Advisory Council here at the Methodist Foundation for Arkansas. He is an attorney here in the Little Rock area, and he's co-founder of the Natural State Law here in Little Rock, and his practice area focuses entirely on estate planning. He actually loves talking about estate planning. I remember that from the first time that I met him here in our office, and he shared how he focused solely on it, how much he enjoys it, and that he really enjoys leading workshops on estate planning details. And he said that about 2 years ago, and we tucked it away and have made it happen, in inviting him to share his expertise along with his passion. Other passions include serving he served a wide array of organizations, from large not-for-profit insurance companies to privately held companies. And he has served as the senior policy advisor to the Arkansas Department of Health and the senior healthcare advisor to Governor Hutchinson. He and his family attend Pulaski Heights United Methodist Church, and he is a friend of the foundation. And so, Jarred, we are so pleased to welcome you, and we appreciate all the insights that you're going to share with us today. So let's give Jarred a warm Zoom welcome. Welcome, Jarred.
Thank you so much, everyone. Yeah, very excited to be here. As Lynn mentioned, I really have, not a lot of attorneys can say this, but I really enjoy what I do for a living. I don't have to, go to court, argue with people. I'm really helping out, because what we're about to talk about is something that it applies to all of us in one way or another. It's a hard reality that we have to come with, that everyone is going to need an estate plan in some capacity at some point. We're all going to pass away. We know that. It's hard for people to admit that sometimes, but it's really important to I tell everybody, sorry, this is something we're going to have to talk about. And most clients understand that, and some get very emotional during this conversation. It just is what it is. But I will say that everyone, once they get finished with it, feels a lot better. It's like, oh, that's something I didn't realize that was weighing me down. And so I think it's important to know that you have options out there, and there's not one. You talk to one attorney, they say you've got to do this. Another attorney says you have to do this. It's good to have information, and about what you need to do to make make this a process that's easy for you. One of my favorite lines I get in this office is, well, I Googled it and therefore I know a little bit about this. I'm like, well, maybe, but Google is not state specific, where estate planning can be estate specific depending on what you want to do. So I always tell all my clients, the very first thing is like, I expect you to know nothing about what I do. The primary role of an estate planner should be an educator, to educate you about what your options are, what might work for you, the pros and cons, and to form a plan together that is going to work best for you. Because if you don't understand what you're doing, then why are you doing it? The attorney is not doing their job. And I tested something out earlier, and the biggest thing is like estate planning can be overwhelming for a client, especially if they've never dealt with it before. And I wanted to start with a little visual aids, what some estate plans can look like. Sometimes they can be very simple and get the job done. Sometimes they can come at you and look like this. This is like a 2-inch 3-ring binder, which is kind of average. But I picked this up yesterday afternoon at 6 o'clock from a client's house. This is probably one of the largest estate plans I've ever seen. It's in a 3-inch, maybe a 4-inch 3-ring binder. All of that says, I just give everything to my only child when I pass away. I don't understand why we're here with this 4-incher. So that's why I've got it in my hands right now. And so I say a lot to say, understand what you do, because I don't know that clients will understand what's in that document. Maybe they do. So I tell everybody there's really 2 ways to go about estate planning. Where you start and where you end is essentially the same. It's just where the costs and the burdens lie along the way. The first way is with a will. And that's what most people think of when they think of estate planning, their last will and testament. Well, what a will is written instructions to the court that says how you want everything divided out and held upon your passing. And that process is what's called probate. Going in front of a judge, hire an attorney, and having a judge oversee everything. Now, it's going to be done exactly how you want it to do. It's just the probate process takes time and ultimately money, because we're having to, there's filing fees, court fees, publication fees, and attorney's fees that have to be paid. So the will is oftentimes cheaper on the front end because a lot of the burdens and the costs are on the back end. And probate in Arkansas it's a minimum of 6 months, because you have to publish it and let it run for 6 months. But realistically, you're looking at 8, 9, 10 months if everything goes pretty smooth. Now, a lot of clients like that option because they say, well, they'll let the cost come out of my estate later on. And I like the cheaper option now. I want to, reserve money. And that's a completely appropriate response to estate planning, because you have something written down and it's going to be carried out. It's just there's the probate process. A lot of people think of probate as a dirty word, and it's oftentimes easily avoidable with a little bit of planning. And so we can usually save the family a little bit of money and certainly a lot of time and potential stress with some planning. But just know that a will oftentimes is treated like a high deductible health insurance plan. Think of it as something you don't necessarily want to have to use anytime soon, but you'll be glad you had it in the event of, an emergency. So a lot of times my younger clients opt to go with a last will and testament because they say, well, I'm young, I'm immune to everything, I'm immortal, I don't need this document. And that's fine, but, it's not necessarily true. So we always like to get something in writing. Now, the other option is with a trust. Now, there's different types of trust, but we're going to use trust as a generic term right here. What a trust is something that you would establish today, and it will hold all of your assets either now or through beneficiary designation. And when you pass away, that trust is still going to exist. And since it holds all of your assets, you are allowed to name somebody or some entity to serve as the trustee of that. And that person's role is to carry out your wishes. So what we do from that is we bypass the court as long as everything is in the trust correctly. And whoever the trustee is can start carrying out your wishes. We don't have this drawn out probate process that's obviously lengthy and can be expensive. So oftentimes the trust is the more expensive option on the front end because there's more work that the attorney has to do, that more work the client has to do. But on the back end, it's oftentimes free because we've already done all the work. and it makes it easier on families. Now, there are different types of trusts, and we'll talk about that here briefly in a moment. But a lot of times the conversation stops right there. The way I have phrased it sounds like, well, gosh, I can save a little bit of money now, but I want to save my family a lot of time and money on the back end. I obviously need to do the trust. That may not be the correct answer. And if the conversation stops right there, I believe oftentimes the attorney may be doing you a disservice, because a trust is about two things. It's about avoiding probate, which is a noble effort, but it's also about control after you pass away. So a lot of times clients will come into my office. They're doing well. They have adult children who are doing well. And I ask them, if you pass away today, can your children inherit everything you have, no strings attached? Here you go. And if they make good decisions, oftentimes they say, yeah. Well, if that's the case, if we're not looking to control those assets, we just say, give it to my children, then oftentimes a trust might not be what's in the client's best interest. Because anything that has a beneficiary designation on it, bank accounts, life insurance policies, most annuities, investments, any financial account typically has a beneficiary on it that says, when I pass away, these assets automatically go to this person or persons or charitable entity. Well, if that's the case, that's taken outside of probate. You can also do that with your home through what's called a beneficiary deed. So if you execute a beneficiary deed and it's filed with the court, you can't just sit in the top drawer of your dresser and be effective. That has to be filed, and make sure all your beneficiaries are set up correctly. You've effectively avoided probate. So just know that that's things that you need to talk through with whomever you're discussing estate planning with. Is that maybe you don't need a trust. Maybe you can get where you need to go outside of setting up a trust and doing it through beneficiary designations. Now, a will still is important. And I tell everybody it's my belt and suspenders document. I don't want to have to need both that and the other documents, but I'll be glad I had it if the time came. So if something slipped through the cracks and there's not a beneficiary designation, then yeah, that will say this is where I want everything to go. Now, there are other documents that come along with estate planning. I know this says demystifying wills and trusts, but just know that there's another portion that I'm going to talk about too. So the wills and trusts typically apply after you pass away. We're talking about giving away assets, holding assets for children or grandchildren or family members' benefits. But you also should be taken care of too while you're still alive. And other documents typically come along with estate planning. Those are powers of attorney documents. There's a financial power of attorney, which talks about who can help take care of paying my bills and just generally day-to-day life if I can't do it myself. A healthcare power of attorney, who can talk to the doctors, make decisions for me if I can't make my own, or I need help making decisions, or I just want someone to help out. Now, those are really important documents, because without those documents, if someone needs to help out, they really don't have any legal authority to do so unless it's written down. The only really option we have is to go in front of a judge, get a guardianship or some sort of judicial approval to take care of those things. And that's stressful, time consuming, and expensive, and frankly, easily avoidable in most instances. So a lot of times clients say, well, I want to talk about this. I'm like, well, that's great. But let's talk about everything else, because we want to also be able to take care of you and not just the family. And, kind of a byproduct of doing the powers of attorney, we really are taking care of your family because it's making life easier for them if they have to help out. And oftentimes there are other documents that I won't really get into unless we have questions on it later on, obviously, that are, so things like an advanced directive or living will, which deals with end of life situations. I think those are really important as well, because it gives your powers of attorney for healthcare some information on how you want your care carried out if they have to make that tough end of life situation. I tell everybody that is a permission slip for the family. It gives them the permission to act in a way that you would want, and for them not to feel bad about any decision that has to be made. So that is what an estate planning package typically consists of. You either have a trust or a will, then the powers of attorney documents to, as we call them, ancillary documents to help assist. Now, I want to go back and talk about the control after you pass away portion. Now, I should have mentioned this on the front end, is that I do a lot of charitable giving. I work with churches and colleges to help facilitate gifts and help advise on that. And we're talking, with the Methodist Foundation right now, and they are supported through oftentimes gifts. So if you have gifts that you want to give, it's important to mention that when drafting your estate plan. And there's a lot of different ways that can go about it. I mean, there are things that you can do. You can give an outright gift. You can set up things through a foundation. There are certain types of trust you can do to help minimize tax burdens, and those are things that can get very complex. And without knowing details of each individual person, I don't want to talk over your head, because we can get really way out in left field talking about something that no one wants to hear about. And I want to make sure that you get your admission price back on this, right? So I want to make sure we're talking about stuff that you came here to hear about, that applies to you generally. Now, there are also other types of trusts, as I mentioned. The most common kind, and what I've been essentially referring to this entire time, is what's called a revocable trust. Those are types of trusts that are also known as a living trust or a family trust, that allows you to make changes to the things, and you control everything completely. You move stuff in and out. It doesn't impact your taxes whatsoever, because the IRS doesn't care that you have one of those. And that's the most common types of trust, because I tell everybody, life is still going to happen. You are going to want to make changes more than likely. However, there are other types of trust that clients often are curious about, and those are called irrevocable trusts. And those types of trusts are things that you put certain assets into it, and once they're in there, they're typically in there. And you usually give up control over those assets. They're set aside for a family member for later on, or you want to make sure there's some, and this is a common question, asset protection. A lot of times people are very concerned about long-term care facilities, skilled nursing facilities, nursing homes is what I grew up having them referred to as, and there's always a concern about that. That is a very specialized area of the law that has to have a lot of considerations, and is a very specific to the individual and their circumstances, whether their marital status, their financial status, and ultimately their end goal is. So just know that a lot of times clients say, I want an irrevocable trust, and they don't understand there's drawbacks, like you lose control over assets. You don't get to have, not only you lose control, oftentimes you lose the benefit of those assets too. A lot of times when I had this happen yesterday, as a matter of fact, it was a 64-year-old lady who recently lost her husband, and she says, I want an irrevocable trust. I'm like, you've worked really hard for the money that you have. Do you want to give up control of that? And she says, oh no, I didn't realize I was going to have to do that. I was like, do you want you want your kids to be over this? Do you want to not have access to a lot of this money? And they said, oh, I didn't realize that. And so just know that there is an education piece that I always come back to, is make sure that you understand estate planning and what you're really wanting. Just because you've seen it on TV or heard it on the radio doesn't necessarily mean that it's going to be the best option for you. Ask questions. I tell this to my clients often, is that shop around. If you're looking for an attorney to do estate planning, talk to multiple attorneys. You very rarely drive off the car lot with the first car you test drove. Think of the attorneys as the same way. There has to be a fit. It's a relationship. It's not a one-time transaction. It is something that you need to be able to feel comfortable talking to the person about, because there are some sensitive topics that you're going to be talking about. And if you don't feel comfortable talking to that attorney, then use somebody else. There are plenty of attorneys out there. So I in class, like, well, I've talked to you, and I'm going to talk to some other attorneys, and I just want to think you should know that. I don't feel bad about that. It's just business on my end, because you have to feel comfortable with what you're doing. Now, let's talk about what the process should look like for estate planning. And if it doesn't look like this, I would question the attorney. What it should look like is you should be provided with documents, and they should go through those documents with you. They need to explain the documents that they've given to you in plain English. I'm gonna give you back my visual aid again. This really makes me nervous when a client walks back and it has this 4-inch 3-ring binder. Did the attorney actually explain what they were signing, or did they just say, "Trust me, sign this. It does what you want it to do"? It shouldn't be that way. It oftentimes is that way, but it shouldn't, because once again, this is an important decision. You should not feel rushed through it. You need to be comfortable with what you do. Now, I do want to jump back and talk about the difference between wills and trust again. There's not a right or wrong answer for most clients. It's just where you want the cost and the burdens to lie. But a lot of times I find that most of my clients can get away with not doing a trust. I tell everybody I have to sleep at night, so we're going to do what's in the best interest of the client. And that's really important, that the client is first and foremost, and that your wishes are taken care of. And I always make sure to include charitable donations and ask them about it, because a lot of clients, we talk about what's important to them. And they say, well, I'm a member of this church. I've been a member of this church for 40 years. I give 10% of every paycheck to this church. I say, great. Is that something you want to continue with upon your passing? When you pass, do you want 10% to go to this church or this organization? And they often say, I didn't think about that. And so it's important to think about what's important to you now and make sure that that's taken care of in any plan that you come up with, because we are representing you and your wishes. Clients all the time say to me, well, I feel bad about doing this. And I say, don't feel bad. It's your money. You earned it. No one is entitled to anything. If you want to give 100% to St. Jude's Hospital, you give 100% to St. Jude's Hospital. It's your money. No one is entitled to it. So don't feel bad about any decision that you make, because at the end of the day, it's yours. Now, one other thing I want to talk about is grandchildren. That's something that comes up often. Clients say, well, I would like to give a gift to my grandchild, and it's usually a minimal gift. And I said, well, you know what? How old's your grandchild? And they said, I've got a 16-year-old grandchild. So would it not mean more to give that grandchild $1,000 on his birthday, and you both get to enjoy it, as opposed to upon your passing then give him $1,000 or her $1,000? So it's one thing I like to talk to about when there's specific gifts, and would it mean a lot more to give it to them now, where you both get to enjoy it, or give it to them later on? Now, the other thing that I mentioned on the trust is control. What does control really look like? And I said that's where the trust is, avoiding probate, but it's control. That can take a lot of different paths. Let's say there are minor children involved. You may want to give something to that minor child or children, but you probably don't want to give them a lot of money today because they're a kid. Technically you can't, but you also probably don't want to give it to when they're 18 either. Because what I tell everybody is 18-year-olds can still do some really dumb things with money. So we typically draft something that says, hold this for their benefit. When they reach a certain age or milestone, give them a portion of it. During that time as we're holding it, take care of them. Maybe pay for school, pay for, insurance, pay for a car, a wedding. But you typically don't want to hold the money forever. At some point, you turn over control of that money. Maybe it is at the 25th birthday, give them half of what's there. Or when they reach the age of 30, give them what's left. Or maybe we're going to stretch it out over a certain number of years. There are things that you can do to make that money last and not be harmful to that person. So I say harmful, if you give a 21-year-old, $2 million, that's probably going to be harmful to them. They may not think so at the time, but they're probably not going to have that money by the time they reach 24. Or if they do, that's not going to be probably spent wisely. And you also have to take into consideration, maybe any sort of special needs that person may have. There are certain government benefits, such as Medicaid being the most common, that are tied to specific benefits that are assets that you may have. There are asset limits. And oftentimes they're pretty minimal. And so we have to take into consideration if this person gets an inheritance or a gift, will that jeopardize their benefits? And if so, we need to think about how we can use that money for their best interest to take care of them, but take care of them in a way that doesn't kick them off any sort of government assistance that they may have, because kicking somebody off just for a couple months to getting back on it's difficult. It can really it from having seen the amount of paperwork that has to be processed to get somebody kicked off and back on. You don't want to put somebody through that. So that's another thing that you need to make sure that's brought up during any sort of conversation that you have concerning estate planning is what will this money do to this person, and will it be used in a way that is going to be put to use? And you can treat everybody different, because once again, I'll say it again, this is your money. These are your assets. You put them to work how you want them put to work. Now, I've said my 30,000-foot overview of like, this is wills and trusts. And I know Lynn said this is typically a group that likes to ask a lot of questions. And I hope so, because I like the back and forth. When I do estate plan with my clients, it's very little paperwork on the front end, and it's all conversation. Because you've already figured this out. I like to talk. And I think talking is a lot more fun, because it allows me to get to know my clients that way, as well as as opposed to giving you something that may you want to fill out, maybe you don't want to fill it out. And it's just going to slow the process down. So with that said, do we have any questions at this point?
Well, Jarred, I'll get us started because we had a question that was asked in our chat earlier on. And it's a question. I have a will and a trust, and Bonnie may need to correct me, but she says there was a new law in about 2019 or so about the beneficiary of her IRA has to take out within 10 years. Is it also true if the IRA is in a trust? Okay, so I see if the law that a beneficiary IRA has to be withdrawn within 10 years, and is it true if it's in the trust as well?
Yeah. So great question. That was a really big change for estate planners. And yeah, about 5 years ago, I think it was 2019, I've been 2020, but it is the new law. Previously, an IRA or this is still the case. An IRA is money that is typically tax deferred. 401k, 403b IRAs that you put money in there that you do not pay income tax on. When you pull that money out, income tax is owed on it by whomever is the person pulling it out. As an individual, you have essentially throughout your lifetime to pay that out. And when you reach a certain age, you start getting what's called required minimum distributions, RMDs. If you pass away, your spouse can inherit that IRA and still have your lifetime to pull it out. They still have their required minimum distributions. All right, that's has been the law, and that still is the law. What changed in 2019 was, previous to that, if I pass away and I name my child or anybody else as the beneficiary of my IRA, they had their entire life to pull out those assets and pay taxes on them. Well, the government got tired of waiting around for their taxes. So what they decided was they would put a 10-year limit on it. I said, all right, for inherited IRAs, we're excluding spouse, you have 10 years that you have to pay the full amount of taxes on this. You can move stuff in and out, at your own leisure. So if you decide you want to take it all out the first year and pay taxes on it, you can. If you want to do it, equal amounts over 10 years, you can do that. It's just that at the end of 10 years, you have to have paid all those taxes. Now, a trust complicates that. And here's why. So an individual, if I'm pulling out of an IRA, I pay taxes based on my income tax bracket. Okay. A trust does not have an income tax bracket. It is technically it does. It's the absolute highest tax bracket, which is not what anybody wants to be paying at. So you have to be very cautious when naming a trust as a beneficiary of an IRA. Now, if it's your IRA, the trust should not own it. You need to keep an IRA in your name for as long as you live. If you want to stretch that money out or control that money through a trust, you need to have a very detailed conversation with an attorney about how that's actually going to look for taxes. Because depending on what your goals are, it may make sense to just name these individuals as beneficiaries and we hold other assets in a trust. Now, that being said, we can construct a trust. It's called a conduit trust that will allow it to essentially hold the IRA assets in the IRA and pull it out and automatically pass it through to an individual without hitting the trust tax rate. There has to be special language put in the trust to do that. Most modern trusts, post 2019 have that language in there. But even then, you still have to be very cautious with it because we want to make sure that we don't take money out of an IRA and just hold it in a trust and there be a significant tax burden on it. That being said, occasionally that is the best option. Maybe we have a child with substance abuse issues that we can't just give him that money over 10 years, or we can't give her this money over a certain amount of time. We need to hold it for their benefit. And yeah, paying that much taxes is not ideal, but it's the better option than just giving it to this child that may, or I say child, it could be anybody, but giving it to this person that could be harmful to them. So if you drafted your trust prior to 2019 and you've named the trust, the beneficiary, the IRA, it would not be a bad idea to consult an attorney just to make sure that we're not going to have a significant tax burden. Because what I tell everybody is, I love charity, but the government's my least favorite charity, right? So I want to make sure that the money's put to use where I want to put to use, whether it's going to my church or everything. And that's when it comes to charitable giving. And I'm kind of steering away from the question, but there's a reason for that. That's where clients can get very creative when it comes to charitable giving to minimize tax burdens when it comes to these qualified accounts like an IRA, that you can set these up in a special trust to stretch it out over long term, as long as you have a charitable inclination with that. So long story short, consult an attorney if you're looking at putting your trust through your IRA through a trust, because there could be some significant tax disadvantages by doing that, but it's hard to know without knowing the specifics of the trust and the specifics of your intent. All right.
Well, we had another question. You'll see. Would you discuss having a lawyer be the executor of a will?
Okay. Good question. I personally don't love that, to be completely honest with you. You can. But typically I like to name an individual or another party to be the executor of the will, especially if that attorney is the one that drafted the will. I personally don't, there are rules as far as what an attorney can do as far as accepting gifts, how they bill, and what they can do for. If I'm drafting a document, I'm not going to get any other gifts, money, or anything out of it, because I will not put myself that for ethical reasons. The only money I should ever receive from the client is the money that I get paid for, assisting you with your estate planning. Being the executor of a will, while allowed for, oftentimes can blur some lines. If I'm drafting a will, I'm going to have a client sign some additional documentation saying, look, while I can be this, I've got to make sure that I'm going to get paid for doing that job later on. So that's not something I get clients that ask me that often, and I just decline it. I don't want to put myself into that situation. That being said, if you have another friend that's an attorney that wants to do it, by all means, absolutely. Just know that if you want your attorney to be the executor, I would encourage you to get maybe some extra disclosures from them, extra engagement letter to say, I'm representing you to draft these documents. But I also agreed later on to represent you as your executor of your will, and this is what the fees will look like then. Because one thing I don't love about the probate process is that I mentioned you don't control it really, because in this scenario, you've passed on. The fees for probate that an attorney can charge can be a lot. There's a sliding scale based off the value of the estate, the amount of work they do, that can get up there in numbers sometimes. So it's a long story short of saying, yeah, they can do it. I'm just very leery of actually of doing that personally.
I see Aaron had a question.
I
Aaron.
do, and this may be too detailed, but I want to try to make it so it might benefit other people too. But I'm the power of attorney for my father's estate. There are 5 siblings. One
Okay.
of them is significantly younger, so he is 16. The rest of us are all 40 and above. So we have my dad's 401k going into the trust. We have it being when he passes away. And I feel like that was primarily done so that my minors, the minor brothers' funds stay, there until he's 30. Is there a way to piecemeal that? Because I've had 3 financial advisors say that it would be better for us to directly inherit our portion, the other 4, but the one is still needing it to stay in trust until he's 30.
Yeah, absolutely. And so and financial advisors, I will say, get very weird about this advice because financial advisors are usually tied into a company that limits what they can do as far as who beneficiaries oftentimes are. Assuming this is possible, oftentimes what I would say is, like, I do like the idea oftentimes of not controlling it. You would inherit yours outright, to piecemeal it 5 different ways. A quarter of it, that's fun. I don't do math in public real well. That's obvious, right? 20% of it goes to each of the 4 siblings. The other 20% shall be held in trust for the benefit of this child. So you could name the trust and have specific language in there that says any money that comes into this trust from this account shall be held for this minor child. Give me the rules. Give it to them every 5 years or whatever.
I think the trust does say that. But
Okay.
should I still name, or should my dad still name the trust as a beneficiary, or should he? Because if he names, he can only do one or the other. He can either name the trust, or he can name all 5 of us as the beneficiaries. And I was told that that is going to overshadow whatever the trust's wishes are. So then my brother would automatically, my younger brother would automatically inherit that, and we would be in trouble.
A beneficiary happens first. So beneficiaries go first, then whatever, then what's ever in the trust. So if nothing ever makes it into the trust, then it doesn't matter.
Right.
So yes, that is correct. But what I think can happen, they'll probably tell me I'm wrong, because occasionally financial advisors do, when it comes to how, I don't tell them how to do their job. I suggest what can be done, and sometimes they tell me it can't be done. What I would name the 4 of you as direct beneficiaries of that account, and the other 5th go into the trust because you should be able to name, I want these 4 kids to get this share. I want this other portion to go here, and that can be the trust. Now, the one caveat to that is that there needs to be language in the trust to reflect that. Because here's why. Is that if you have in the trust, I give everything to my 5 kids equally, I want a 5th of it to go to in a trust for this. But if y'all 4 get y'all's outright, then we have a 5th of it go into the trust. An argument could be made that you now get a 5th of that, because you say a 5th of whatever's in the trust you get. And so it needs to include some language. I typically say, take into consideration any beneficiary gifts that have been made and calculation of these people's share. That way we look at outside, any sort of, like, you got that money coming from Fidelity or Edward Jones or whatever. When we divide the trust up, a 5th, a 5th, a 5th, a 5th, and so forth, we look back and say, oh, you've already gotten part of your portion there.
Okay.
Yeah. And on that, we might also, it's one of those things, it can be very specific, right? I think we're maybe getting a little bit too in the weeds, but what's worth mentioning too is that this, as a statement for everything, not everything has to be divided equally. And what I mean by that is, when someone passes, we look at the total value of the estate or the total value of the trust and divide that according to the rules. So if is this your scenario, not everything has to be divided a fifth, a fifth, a fifth. We don't look at this account, divide it, 20% each. We don't look at the home, divide it to 20% each. We look at the big picture and make sure everybody gets equal shares of the big picture. And it makes the administration a lot easier because we're not having to go through everything and line item and dole out. Some person might raise their hand and say, well, I want the home. The other four of you say, I don't want the home. We know the home's worth $250,000. Well, let's just make sure that my $250,000 looks differently than your 250. And so it requires getting appraisals sometimes and things like that. But that's just a way to make sure it's fair and there's no fighting, but also an easier administration as opposed to cutting everything that you have into equal slivers.
If I wanted to hire you to look this over, does that make any sense? Because he's in Virginia and Virginia law is probably different.
Your dad's in Virginia? Yeah. It would need to be an attorney that's licensed. It's where you are domiciled. All right. And since, because as I mentioned at the very start, Google's great for law sometimes, but Google's oftentimes not state specific. And this is free legal advice for everybody. If you ever Google something and you get the top Google AI says this, don't take that for gospel. It is probably about 40% right. So just know that is Google AI or any AI. Chat GPT is not the end all be all of legal advice. And so Aaron, in your situation, I think it would be worth talking to an attorney. That should be a pretty brief conversation. Maybe it's not, but it should be. Just to say, hey, based off of Virginia law, this is what we have going on. Is this set up in a way that makes sense, right?
Thank you. Yes, his own attorney is not helpful, so I would need to get another attorney to help.
Yeah, and I will make this statement as well about attorneys. I come from a really small town in South Arkansas, okay? I'm used to the small town attorneys. They serve their purpose, right? They're good, and I'm not going to knock them. Estate planning is fairly specific, and there's a lot of intricacies that I think a lot of people don't realize. And so oftentimes an attorney that has a general practice sometimes can miss little things. So if you're looking at talking to another attorney out there, I would recommend somebody that holds themselves out as an estate planning attorney. If you click on their website and it says, I do estate planning, DUIs, child custody, divorces, and everything, probably not the attorney I would use for that, because there's some tax implications there that they may not be aware of. All right, now I see some good questions here from H. Moore that I want to address. So thank you, some great ones. So the first one is a statement of guidance or last burial wishes or things like that. I do not put those in my documents. However, I provide a place for you to put those. So I give a binder to my clients and I tell them in the very front pocket, put that information in there. The reason I don't put it in my wills or other documents is because, unfortunately, those decisions, funeral memorial service, funeral provider, hymn, scriptures, pallbearers, preacher, things like that, those are things that we're going to need to know pretty fast. You have 5 years to probate a will. And so if you bury that in a will, someone 2 years from now may feel very awkward and bad if they come to it and say, oh gosh, this is not what they wanted. So tell your family what you want. Write it down, give them a letter, tell them where they can find that letter. Communication is key. I don't like surprises. If you have something that you want your family to know, they need to know that. Don't have it, 6 pages into a will and hope, have an attorney explain it to them. Talk to them, because through that conversation, they're going to have an idea of what you are actually going to want. And that dialogue is incredibly important. And I encourage you that if you write it down, update it occasionally, please. From personal experience, when my grandmother passed away, she had a letter. She had it lined out. I want to be buried here. I want these my pallbearers. This is the preacher. I want these songs sung. I want to be buried in this dress. I mean, she had it all lined out. The problem was she made it about 20 years before she died. And so 4 of the pallbearers were dead, the preacher was dead, and that dress was long gone. And so my mom worried herself to death trying to figure out how to handle all this. And that's just one less thing that my mom didn't need to be worrying about when my grandmother passed. But it's, it was important. And so make it out, encourage that. Don't necessarily, keep it with your documents. Just don't necessarily incorporate it into your will and think that needs to be the only place it is. If you want to put it in your will, that's fine. I would put it somewhere else is there. And you had a follow-up question too, about distribution of personal property. Okay. I call this stuff, things. If I picked up your home and turned it upside down and shook it really hard, everything that fell out, what happens to that? All right. Whether you do a will or a trust, and attorneys are kind of 50-50 on where they actually put this. So if you do a trust, some attorney may stick it in the will, some sticks it in the trust. There's not a right or wrong answer necessarily. I tend to put it in the trust if we're doing a trust. In Arkansas, you can say where you want stuff to go, handwrite it out, sign, date it, keep it with your documents. All wills, I say all wills, every will that I draft or every trust I draft mentions, it says I may attach a letter or a list saying where I want stuff to go. Doesn't have to be notarized, just needs to be signed and dated. Now, you can't give away money. You can't give away real estate or business interests. We're only dealing with tangible personal property, whether that's fishing equipment, coin collections, jewelry, anything like that. You can be as specific or as generic. You can say, I give all my tools in my shed to my cousin. Or you may say, I give this specific piece of, jewelry that I inherited through generations to my niece. And you typically can update that at any time. That's one of the things to discuss while drafting your documents, because some attorneys like to include very, very specific gifts in the trust or in the will. I'm not a huge fan of that because things are going to change. Now it's different if you say I've got a Pablo Picasso on the wall and I want that to go to my cousin. Yeah, let's put that in there because we want to make sure that doesn't end up in a yard sale, right? But don't necessarily feel that you have to give away every pot and pan like in the trust. I will tell you that I also like the fact that you can update it anytime you want to. If it's hardwired in the will or the trust, it's hard to do that. You need to get an amendment. But I once had a client and she showed me a photo. She did this. She said she's got 6 grandchildren. And so she wrote down where she wanted all the stuff to go on her thing and she put it on the refrigerator. And she said, this is what you're getting. And if you make me mad, I'm coming, I'm striking your name out and giving it to somebody else. And she did it. She sent me a photo of it. Right.
I like that. So do you see that next question, Jarred? Is there a difference between an elder care attorney and an estate planning attorney, or are they the same thing?
There is a difference. All right. This is a point of caution that I like to put to everybody. So I hold myself out as an estate planner. I work with clients. I had a client in my office, 21 years old. Actually, it came in last week. 21 years old. He's wanting to get stuff ready. I said, "Good, let's take care of this." I also have a client that I think my oldest client is 103 right now. Every time I talk to him, he's on the treadmill. I love it. He's like, "Hold on, I get off the treadmill. I can't hear you." I'm like, all right, perfect. I love this guy. And so I hold myself out as an estate planner that we're going to talk about generally what happens with everything and holding everything should you pass away, as well as a lot of charitable giving. I would consider that estate planning. When we deal with elder care, there's a very specific branch of law that it goes with, and it typically deals with asset protection for Medicaid purposes. We're dealing with skilled nursing facilities. We want to make sure that those assets are protected for future generations. That is typically what's considered an elder care attorney. Now, powers of attorneys and things like that, anybody can handle that. But my word of caution on that is that a lot of times companies that do that hold themselves out as attorneys when they're really salesmen. They may have one attorney that works for in a group of 50 people, but they're really trying to sell insurance products and things like that. So if an attorney ever feels very pushy about what they're trying to do or starts trying to sell you something, think of it like someone who just showed up to your door trying to sign you up on the new phone service. Be very cautious, because there is a lot of, in my opinion, abuse from attorneys that are in that field, where they can sign clients up on for just ridiculous amounts of money for products that they may not necessarily need, and it might not be the best. But so yeah, so there is a difference. So all elder care or elder law attorneys are estate planners. Not all estate planners are elder law, because it's a very specific field. And if that is something that you're interested in, I definitely encourage you to do research. And more than any attorney, I said, don't drive off the lot with the first car you drive. Specifically when it comes to elder law, talk to multiples, because it's a very stressful time for a lot of families if they're having to deal with them. And they oftentimes just talk to the first attorney that they find in the phone book or on the internet, and that might not be the best fit for them. So just a word of caution on that one.
Question. Thank you, Brenda. Any other questions? We've still got some time.
Yes, I have.
Yes, sir, Jerry.
You talked earlier about disposing or handling of residents in the scenario of using a will, and how do you handle that final disposition of a house if I'm using a will and naming beneficiaries?
Yeah. And so ultimately there's what's called a beneficiary deed. And it says that this is my home for as long as I live. When I pass away, it automatically passes to this person or individuals. And what happens is we take your current deed, and create this beneficiary deed based on that. And it's filed with the courthouse. And there it sits. They're going to match up at the courthouse. And it says, whatever I own in this house when I pass, it's going to go to these individuals. If I don't own that home, then I don't own that home. I tell everybody, I could give you a beneficiary deed on the Arkansas State Capitol that says, when I die, whatever I own, you get. Well, don't count on much, because I don't own it. So you still can buy, sell, refinance it. It's just like a beneficiary on a bank account that you have. It's yours until you pass, and it automatically goes to somebody else.
Okay, I got it. Thank you.
Did it answer your question? All right, thank you, Jerry.
Any other questions? Well, go ahead.
Go ahead, Lynn.
No, I'm just looking around the Zoom room to see if there are any folks who are raising hands or looking like they're unmuting to ask a question.
I see a question that from John Wilcher that I want to make sure we get
Okay.
asked. It says, if all assets have a designated beneficiary, spouse, and only child, except automobile, is there a need for a separate will and or trust? Trust, most likely not necessary. The will, possibly not necessary. But I still think it's a good idea as that belt and suspenders document, as I mentioned. And here's why. I find this, and this happens a fair amount, that when people have purchased a home that have lived in it for a really long time, oftentimes they just put the home in the husband's name. It's almost always husband. That's just the way things worked back then. And you would think that if nothing is written down and husband passes away, it would all go to spouse. That's not necessarily the case. It's the spouse has an interest in it, but so do the kids. And that can lead to some very interesting dynamics and conversations later on. So what I usually recommend is that get a will, because what the will typically says is, if something slips through the cracks, I give everything to my spouse. That way, that scenario I just laid out, in case the home is just in one person's name, it doesn't come into play. That being said, it's almost always home that's the problem, or real estate. If it's just bank accounts that you're renting or living with a kid, and you've got all your money in these two accounts, and you're looking plainly at them, do I need, and the beneficiaries are set up, and there's only the car. There's a fair amount of times clients leave my office and they don't have a will because they don't necessarily need one. It's important to have powers of attorneys because those are to take care of you, and there's really no way around that without going to court. The automobile. Now, there's a couple different ways to approach that. You can't do anything with a car that you still owe money on. You don't have the title yet. But once you have the title, there's Arkansas DMV does what's called gosh, I had this form set out and I stuck it away somewhere. But you can do a beneficiary designation on the title of a car. It's a lot of paper. It's a page and a half form to fill out. It's not difficult. When you pass, it automatically passes to the child or whomever. However, automobiles are the easiest thing dealt with after someone passes away. If someone passes away, you can do what's called an affidavit of heirship at the DMV and get the car. It's only a half-page form. It doesn't even look like it's real. And that transfers the car to whomever upon the passing. So I don't worry too much about cars, whether you're doing a will, trust, or nothing, because cars are pretty easily dealt with if you own them outright.
Thank you for catching that one. Are there any other questions? Well, in closing, Jarred, I'm going to put you on the spot and say, as we're wrapping up, let me make sure, as we are wrapping up our demystifying wills and trusts, what are 3 quick take homes that you hope we have all heard this morning?
Oh, goodness.
I know
Put
that's
me on the spot.
really on the spot.
I told you I do math in public real well. I don't know if they put on spot in public. Okay. No, what I want to make clear is that the number one is that understand what you have. Talk with an attorney, talk with the family to make sure there's a dialogue between all people involved, because talking is important. The second one is a trust is not always the right call for people. Sometimes a will can get you where you need to go, especially with beneficiary designations. And the third is do something. And what I mean by that is clients, they apologize. It's one of the first things that always happens. They apologize. Well, I'm so sorry. I'm just now getting around to doing this. And I say, you know what? It's never too late until it is. So we're still in good shape right now. Okay. So just consider it and get everything in order for yourself and your family, because when the time comes that someone passes away, the less they have to worry about these things and the more time they have to grieve and to be with family, they're going to appreciate it.
Well, thank you so much, Jarred. This has been very helpful. Let's all show our appreciation with another Zoom round of applause, or we can do hands. Thank you, Jarred, for your time with us this morning. We are very grateful for your expertise and your passion for this work. Friends, as I said, this has been recorded. We'll be capturing the recording, and I'll email this out to everyone who registered for this event, along with Jarred's contact information again, and a link on to our foundation website that has our list of our professional advisory council members. So attorneys like Jarred, who are estate planning lawyers and have had a connection with the foundation or their local United Methodist Church. So as Jarred has said, and we at the foundation we echo this every chance that we get. It is always worth discussing your estate plans with an attorney. You have free options galore on the internet, as Jarred said. He was really charitable and said you could trust about 40%. We say if you get it for free, you're going to get what you pay for.
Yeah.
And a free online resource for your estate planning. It does not understand the nuances of Arkansas estate law, nor will it understand the nuances of your family, of your situation. So we encourage you to connect with an attorney so that you can have your legacy planned, and it can have that peace of mind now, and such a gift to those who come after you. So Jarred, thank you for your time, and friends, thank you so much for joining us. We hope that you have a great rest of your day and are gearing up for a fantastic weekend. And happy National Make a Will Month to everybody. We've been celebrating hard at the Methodist Foundation. August is National Make a Will Month. So celebrate by making a will or updating your will. So, all right, friends, have a great day. Thank you for joining.
Thank you so much, everyone. Thank you. It was great.
Thank you. Thank you, friends. Y'all have a great day.